Hello everyone, this is Jennifer. So in this video we're going to look into Indian Contract Act 1872. So the first that we're going to look into is to have an introduction about the act. So basically this act, which is the Indian Contract Act, came into force on 1st September 1872. So meaning to tell it has come into force before the independence of India. So which means the legislations were made by the Britishers. And it applies to the whole of India except Jammu and Kashmir. It deals with the general principles of the contracts and also contains the special contracts only. So basically this act deals with the law relating to various contracts. Okay, so the terms, the conditions, the breaching of the contract, the performance of the contract, or the remedies for the breach of the contract, etc. So basically in this act there are 266 sections. So the first section is section 1 to 75 talks about the general provisions. Section 76 to 123 talks about the sales of goods. Section 124 to 147 talks about indemnity and guarantee. Section 148 to 181 talks about bailment and pledge. Section 182 to 238 talks about agencies, and section 239 to 266 talks about partnership. So if you see section 76 to 123, which is sales of goods, was removed from this and a separate act was passed as Sales of Goods Act, so which we will be studying later. And the last section, which is the division, that is section 239 to 266, which is partnership, was again removed from here and a separate act was made, which is Indian Partnership Act. So all contracts are agreements, but all agreements are not contracts. To put that in an example, all agreements are not contracts. For example, there is a conversation between a father and a son telling if the son gets more than 80% in his exam, the father will buy him a bicycle. So which is an agreement between both of them. So the son scores 80% and above and comes and asks his father to buy a bicycle. So this is a personal social obligation or just an agreement between the father and the son. Why it is not a contract? Because it is not enforceable by law. Okay. Only when it is enforceable by law, it becomes a contract. But for every contract, there is an agreement between the parties. So every agreement cannot be a contract, but all contracts are agreements. So to put that in example, another example, for example, A sells his property to B for 1 lakh rupees. So in this there are basically different steps involved. First, A gives an offer to B that he is going to sell his property. Okay. So if B wants it, he can accept the offer. So when B accepts the offer, it becomes a promise. Okay. So when B accepts the offer, it becomes a promise between the parties that B will be paying 1 lakh rupees for buying the property. Okay, so what is the consideration in it? 1 lakh rupees. And agreement is A and B have agreed to sell or buy the property respectively. And the next one is enforceable. Enforceable is nothing but forced by law. Okay, so when agreements go on a void, okay, the actions can be taken in the name of law. Okay, so that is enforceable by law. The terms, the condition, everything is enforceable by law. So when it is enforceable by law, it becomes a contract. So the requirement of an agreement to become a contract is only when it is enforced by law. So meaning and definition of contracts. So meaning, a contract is an agreement which is enforceable which is forced by law, which offers the personal rights and imposes personal obligation, for which the law protects the personal rights and enforces against the parties to the agreement. So basically, a contract is enforceable by law, which basically tells that both the party, when they have agreed for an obligation or for an agreement, it needs to be done. If it is not done, okay, the remittance or the remedy of it will be taken will be actioned by the law. Okay, so in order to protect the parties of the agreement. So the definition of contract is, according to section 2 subsection H of the Indian Contract Act 1872, an agreement enforceable by law is a contract. So as I told you earlier, when an agreement becomes forced by law, okay, that will be known as a contract. So the next part is essentials of a contract. So these are the various essentials of a contract. The first one is offer and acceptance. So basically an agreement is a result of an offer and the acceptance. So one person will offer for something and the other person will accept it. For example, if A is offering to sell his property to B, okay, so the acceptance will be made by B to buy the property. So it is a combination of both offer and acceptance. Thus basically there are two parties in a contract. One is the offerer and the other one is the offeree. So an offer to do or not to do to a definite act or acts is made by one person is called the offerer. So who is offering to the other person. When the proposal or the offer is accepted by the other party, he is known as the offeree. So our second essential is free consent. An agreement to be made enforceable must always be of free consent. That is, the offerer and the offeree should be of the same mind without any kind of mistake, fraud or misrepresentation or influence. So they should just come into an agreement to fulfill the agreement with free consent, not by force or by influence or just to do a mistake or misinterpretation, misrepresentation, or just for a fraud case. Nothing should come into the picture. It should be of a free consent between both the parties. Point number 3 is contractual capacity. So the parties who enter into a contract, okay, they should always be competent to do so. Okay, so the people who are said to be competent should be of the correct age, should not be a minor but a major, should be of sound mind and should be in a way eligible to get into a contract. Okay, so the incapacity basically arises when a minor enters into a contract, or a drunken person, or someone who is loquacy or idiocy. If one of the parties to the contract suffers from any of the incapacity to enter the contract, then it cannot be enforced by law. Point number 4 is lawful consideration. So an agreement will become enforceable, okay, enforceable by law only when there is a consideration. Okay, consideration is nothing but something given or taken for something in return. If an agreement is not supported by any consideration, then it will be known as a naked agreement or a bare agreement, which is not enforceable by law. Point number 5, lawful object. The object of the agreement should always be lawful. It should not be unlawful. If the object is forbidden by immoral or opposed to public policies or societal concepts, then it will become a unlawful. So any agreement with an unlawful object cannot be enforceable by law or cannot be enforced by law. So a lawful object is always essential to make it a valid contract. The next one is not expressly declared void. So an agreement must not have been expressively declared to be void under any law. So for example, what is a void kind of contract is? A void contract is which cannot be enforced for the subsequent times. Okay, maybe enforced for the first time but not for the subsequent times. For example, if we are having an agreement with a foreign country to export or to import goods and services, when there's a war between our country and the foreign country, so the subsequent enforcement of the contract will become a void which cannot be enforced. So not expressively declared void. So void agreements cannot be enforced by law. The next one is possibly of performance. So what they are promising to perform should be of the possible nature. So impossible things cannot be performed. When there is impossible stuff, then it will not be part of the contract. So only the performance that you are going to put into action should be of the possible nature. So for example, A tells B that I'm going to share 50% of the treasure that I get, which is created of magic. Okay, so which is impossible in nature at times. You cannot predict whether that magic is going to happen or not. So such impossibility of performance cannot become a part of the contract. So only possibility of performance becomes a part of the contract. The next one is certainty of terms. So performance should always be possible in nature. The next one is certainty of terms. The terms of the agreement must be very, very certain. So uncertain terms make the agreement unenforceable. So the terms and conditions which they put in the contract must be very, very certain that is going to happen. Okay. The next one, intention to create legal relationship. When two parties enter into agreement, their intention must always be to create a legal relationship. Okay, so in the absence of such an intention, the agreement cannot be enforced by law. It will become a social kind of contracts or social obligations. The next one is legal formalities. One aspect of the legal formalities is whether the agreement must be written or it can also be oral. But most preferably, a contract will always be in a written form. So the registration is also another aspect of the legal formalities. Once after you have a contract written, then you can register it, and it becomes compulsory in cases of properties, gifts or mortgages, etc. So these documents containing agreements need to be stamped and attested under the law. So thank you everyone.